The session this morning began with a wider discussion on affirmative action in the private sector. I take it that we had a extended discussion on what the structural possibilities of affirmative action in the private sector. I think Bharat asked a similar question, and Anand Teltumde expanded on that possibility in great detail. I suppose that no one who takes the data seriously can make a structural argument that affirmative action standing alone is a social transformative engine. I don't think that, I don't know what theory of change Anand's intervention was working at. Because if the theory of change is that the actual numbers by affirmative action alone, we would generate social structural change, then that theory is misplaced. The only argument, and the way I've always understood affirmative action debates or reservation debates, and the way they were carried out in the Constituent Assembly, were that these debates were as much about participation in public institutions and in various sectors of the economy and society, which by itself is not the ultimate leveler, but there's some symbolic force to presences in various institutions. And so it can only be that kind of a theory of change that could support a policy push for affirmative action in the private sector. That's certainly how I've understood it. That's not the main part of my intervention today. I'm not looking to make either the economic or the social argument for affirmative action in the private sector. It must be made, and I take it that others will make it in the rest of the day. The part that I'm going to focus on is on the legal argument and the constitutional argument. And the question I ask is one of possibility. Is it possible? And if it's possible, how? Professor Jaffet started this morning by talking about the Bengaluru initiative, which is almost 10 years old now, and we explored this question then, and I think looking back, a little naively in some parts. So what I'm interested in doing today is to try and cap the last 10, 12 years. Look at what's changed in Indian law, and look at American South African law briefly. And try and sketch what might look like a possible framework, a possible approach in the Indian context. There were a few brief discussions in the first session on what are the constitutional provisions on equality and reservation in India. And I want to spend a little bit of time here, because I think both by way of comparative contrast and by general illumination, it's useful to get some baselines. The important point about anti-discrimination in the Constitution is that it binds the state. It does not expressly apply to the private sector. And we also have provisions that allow for reservations. I'll just call them special provisions. They don't really say reservations, they say special provisions may be made. And those could be preferences, they could be quotas, but the device of choice for Indian administrators has been the quota. And so in India, in Indian debates, we speak in terms of quotas, really, everywhere. The Constitution, though, speaks in terms of special provisions. And so that admits of a wider range of policy measures in this field. 15.4, 16.4, and Article 46 are the key provisions that one would pay attention to. 15.4 applies to public education. 16.4 applies to public employment. And 46 is a general directive principle that urges the state to make special provisions to prevent social injustice and exploitation of the scheduled caste, scheduled tribes, and other weaker sections. What's important to remember with 15.4 and 16.4 is that they apply to public education and public employment respectively. 46 does not, but 15.4 and 16.4 have specific application to public education and employment. The second is that all of the affirmative action policies operationalized through executive orders, not through legislation. These executive orders are made by the union and state government using the constitutional power. There's no intervening legislation that sketches out the scope and extent of these provisions. What's equally important in India, in the Indian constitutional structure, is to note that the special provisions are unrelated to the concept of discrimination. There is no requirement in the Indian constitution that one needs to show discrimination first and then make affirmative action possible. We can make affirmative action anyway. And 16.4 speaks in the language of adequate representation. And so the concern is with distributive consequences, not with discrimination. We incidentally don't have overarching anti-discrimination legislation that covers the public and private sphere. We have some minor labor law regulation with respect to gender pay equity and so on, but there isn't an overarching anti-discrimination statute. It's interesting to see that Article 15.5, which has been introduced in the last decade, allows for affirmative action or special provisions in private educational institutions, but there is no corresponding provision in private employment. So private labor markets don't have an express constitutional provision to support it. So 15.5 was introduced by amendment. It has been tested in the court and upheld in Ashok Kumar Thakur. So the question that, against this legal framework, this legal backdrop, question we should ask ourselves is, can the state insert affirmative action requirements into the private labor markets? Is it constitutionally valid? And I want to track 3 ways it could be done, and I'm going to be slightly ambiguous about exactly how constitutional it is, because that would need more explanation, but I can try and sketch broad outlines of an argument. So Article 14 is our general equality, equal protection provision in the Constitution, and Article 46 can potentially be horizontally applied, just applied directly using executive action. Would this be upheld in the absence of Article 15.5 kind of provision? Is the key question for the constitutional validity of this strategy. And the Indian courts have gone in both directions on the question of a horizontal application of Article 14. In the Zoroastrian cooperative housing discrimination cases, the court said it cannot be applied to a private housing society. But subsequently in Anuj Garg and in the Makeup Artist case last year, the court has held that a private union and a private bar that Article 14 would apply to them in cases of gender discrimination. So the court has kind of not squared up its jurisprudence on the horizontal application of Article 14, and it's possible, one might say, that that the court might not strike down executive action that directly applied affirmative action requirements to the private labor market. We already have evidence of preferences in contracting and tendering by state government law, and these have not been struck down. I don't think they've been challenged either. So they haven't been upheld or struck down. So there's some ambivalence about this strategy taken as a whole. The second legal strategy would be to take the constitutional legislation route. Something like what the Right to Education Act of 2009 is to Article 21A of the Constitution. That is that the union or a state government can pass a law to directly implement a constitutional right. Now, there are not many rights that have legislations to support them. The right to education is one example. Interestingly, the Right to Education Act provides for education, for quotas in private educational institutions. So this is a possibility that the union or a state can pass a law under Article 14 read with Article 46, mandating affirmative action in private labor markets. And it has a reasonable chance of being upheld. The last route would be for a union or state legislature to pass ordinary legislation that had preferences or quotas. We see evidence of this with the Stock Exchange Board of India Act, which authorizes equitable gender representation on company boards. Those regulations have been upheld. So there's some evidence, at least with respect to gender, that these kinds of ordinary legislations could well initiate an affirmative action policy in the private sector. Having said all of this, none of these three strategies have been tried. So it's as lawyers, we would caveat the argument saying that it hasn't been tested, but all of these are plausible. How should we imagine an affirmative action model? Should we learn from models that have been applied elsewhere and try and mimic them, or should we go in a different direction? And I'm going to argue to conclude that maybe we have something to learn, but there might be negative lessons. They're lessons of what we should avoid. And we might want to chart a different route with affirmative action in India. The first model is a model that rests in an anti-discrimination core. The United States, the United Kingdom, and South Africa all adopt important legislation, which then offers the anti-discrimination legislation, which then offers the backdrop to affirmative action policy. There are very serious problems with this kind of approach, and I'm only quickly going to caption them. Direct discrimination is difficult to prove. The whole intentionality game is difficult even in jurisdictions which have significantly better evidence gathering mechanisms. I think that there's no hope of a direct discrimination type model in India. Indirect discrimination still draws on very significant burdens of proof. You will need to develop enough data about the nature of the labor pool, about the nature of the recruitment process, and show that structural discrimination has indeed taken place. Even if Professor Jones talked about the Croissant standards, if India were to go down that route and have some sort of a strict construction of equality law, very little would get done. Moreover, this anti-discrimination model would work well if you have strong bureaucratic agencies and efficient courts, neither of which is in evidence in India, in other realms. So it's futile to believe that somehow equality law is going to produce that. The second model, which has been discussed in the Indian debates and elsewhere, is a diversity model. It has as its advantage a forward-looking justification that doesn't need to show discrimination per se. The US university cases, and we briefly touched upon them in the morning, suggest that diversity rationales can apply in education. Its applicability to employment is more suspect, and I'm going to just say a little bit about that. But even its application to the education arena is in some doubt. And when Fisher and Texas go back to the Supreme Court later this year, we might have another story to tell, and diversity might not be such a resting the entire argument for affirmative action on diversity may be a folly. Its soft law adoption in private labor markets that Professor Brown spoke about there's been some good evidence to show that when private employers themselves adopt diversity policies, good results are possible. And I think there's something to learn from that evidence, but I'm not too clear in my mind that diversity is essential as both a rhetorical and a legal scaffolding for this kind of exercise. The last point that I would make is that while diversity has some traction in Indian debates, there's very little normative support for a diversity rationale. There's nothing in the Constitution that per se speaks in the language of diversity, and there is nothing in our public discourse that immediately attaches a normative weight to the value of diversity. Moreover, there's very little empirical evidence that makes the business case for diversity. Ashwini Deshpande's railway study at best makes the negative case. It makes the case that diversity or quotas more specifically doesn't negatively affect efficiency. There's yet to be made the positive case that diversity improves profits or efficiency in organizations. So my sense is that even the empirical case is hardly made out in India as we speak. So which way would we go? And I'm going to close with this. I would argue that the most sound normative and legal basis to rest an argument for affirmative action is a plain distributive justice argument. And that's an argument that argues that makes the case for adequate representation in all spheres of public and private life with a view to get rid of social injustice and exploitation. So it's completely forward-looking in its orientation. It has to make some normative argument about what is adequate representation, what is a reasonable distribution of particular goods, and it's that kind of case that the Constitution rests on. In an important case in the 1970s, which very few people read, called N.M. Thomas, the court clarifies that Indian affirmative action doesn't rest on a corrective justice tort law model. We're not looking for discrimination which results in, which then gives rise to an affirmative action or reservation policy. The argument in the Constitution is one where we look to distribution straight away. And I suppose that, and I'll stop here, that the best argument for affirmative action in the private sector, to my mind, would be a similar argument. Would not be an argument that seeks to establish discrimination at every count, but one that makes a direct claim to a particular end goal of distribution of these valuable resources and opportunities. Thank you.